Finally, I figured it out.
Awesome.
Okay.
Nadia and Rick, you guys can start. All good.
Thank you so much, Tove. Good morning, everybody. It's so good to have you this morning on the call. And it gives me the greatest pleasure to introduce one of the most awesome experts that I've ever had the pleasure of working for the past 10 years. And that is Ric Martin, who's looking extremely dashing with his salt and pepper hair. So a little bit about Ric Martin. Ric Martin is the founding director of Ric Martin Incorporated. He has about over 27 years of post-admission experience. Prior to starting his own practice, he was also a director at Dyersons and Rutledge and Medici. He's now flying solo with his very successful firm. And I can honestly tell you, whenever our clients are in a pickle, he's one of our go-to experts. Apart from just being very familiar with HPCSA complaints, he does work on very, very high profile medical malpractice litigation and is a solid insurance specialist. So thank you for joining us, Ric. And we're looking forward to the session today where you're actually going to take us through the Health Professions Council of South Africa complaints, take us through some trends, and actually talk us through some actual stats. So over to you, Ric.
Thank you, Nadia. Thank you for that warm introduction. I wasn't sure that you were talking about me. It sounded as though you were talking about somebody else, but thank you so much for the kind words. To all the participants, good morning. Apologies for the technical difficulties that comes with age. Once you are acquainted with one platform, and I am very much acquainted with Microsoft Teams, it becomes very difficult when you have to Zoom, and I understand that this platform also zooms in on my face. My apologies for that. The Health Professions Council is one of the regulatory organizations or regulatory bodies within the South African legal sphere. It stands side by side with other regulatory bodies that you will be acquainted with, to mention but a few: EXA, the South African Pharmacy Council, the South African Veterinary Council, the South African Nursing Council, the Allied Health Professions Council, the Financial Services Conduct Authority, the FACE Ombud, etc. These organizations are all deemed to be the custos morum, or the custodians of the professions and the ethical standards that are applied within the professions. I have the pleasure, or perhaps some would call it the displeasure, of not only representing insured individuals, health professionals, and associated professionals at the various bodies, but I also prosecute as pro forma complainant at the South African Veterinary Council. So I'm well versed with the systems and the procedures that are followed at regulatory bodies. Today, we're going to focus our attention to the Health Profession Council, and this has a significant impact on all forms of financial service providers, both underwriters as well as brokers. In the medical fraternity, and perhaps dealing with all regulatory bodies, the critical motto should be prevention is better than cure. And what do we mean by this? Is we say, take steps to guard against ensuing risks. Don't wait until a claim arises or a complaint is lodged. Make sure that your preparatory work is done so that you don't have complaints against you. Unfortunately, in our society, complaints are inevitable, and these will come about as financial service providers would also realize, with complaints with the FSCA and complaints with the FACE Ombud, etc. If one looks at the complaints processes, in short, the way these function is that members of the public can lodge complaints where they are dissatisfied with the service levels that they've received at any or from any health professional. Now, depending upon whether it's a doctor or a nurse or a pharmacist, the complaint would be referred to the correct body. I have to caution at this stage that there are multiple regulatory bodies that have jurisdiction at the same time over the same matter. And you would ask me why that is. And it's a very unique situation that we confront, because we have the Health Professions Council of South Africa, but then we also have the Office of the Health Standards Compliance. In addition, we have the South African Human Rights Commission. And I have seen complaints at all three bodies to be dealt with at the same time. So it is, one should tread cautiously. The Human Rights Commission specifically looks at complaints of racism, impairment of dignity, etc. So the health professionals should be wary, and this to a large degree boils down to the bedside manner of the professional, because people are often likely to complain where they feel that they have been insulted, their dignity impaired, and it all has to do with how the professional has dealt with the individual. But getting back to the Health Professions Council, at the Health Professions Council, there are, in essence, two streams that are followed. So a complaint would be received at the registry's office and the complaint would be assessed. It will go to either the Health Ombudsman's office for an investigation, or it would go to a complaints investigator who works in direct contact with one of the preliminary committees established in terms of the various boards. The Ombudsman tries to mediate the complaints, and upon receipt of the complaint would be referred to the professional for a response or an explanation. And once the explanation is received, the Ombudsman would then try to mediate the situation. This may be in the form of correspondence. It may also be in the form of a mediation meeting. Now, lawyers do not have any standing and we cannot participate in the mediation, but we are allowed to be observers. And your observer status, you can purely see if the Ombudsman is following the correct procedures and he is not biased towards either one of the parties. The difficulty with the referral to the Ombudsman is invariably the nature of the complaints referred to the Ombudsman would be in connection with accounts or payment of accounts, although other types of complaints are also referred to the Ombudsman. And what our experience has been is that the Ombudsman invariably tries to get the professional to write off the outstanding account, notwithstanding the fact that the services were properly rendered. Once the mediation has taken place, a determination is then sent to the parties. The difficulty with the Ombudsman is that the complainant does not have to accept the determination. I have recently dealt with a matter where a complainant had a minor injury to his Achilles tendon. Well, in fact, he only severed the skin over the tendon. He did not sever the tendon, but he had decided that that injury was sufficient for him to be medically boarded and to spend the rest of his days sitting at home earning a pension. And when that didn't occur, he referred the professional who had attended to him initially to the health ombud. The matter was fully investigated. He didn't accept the determination. The matter was referred to a preliminary committee, and the committee also found no evidence of unprofessional conduct. Not dissatisfied with that outcome, the complainant then complained a new complaint against the practitioner's partner. What had happened is that the patient had initially for the injury been treated by the one doctor, and he then returned, or he was referred back for an assessment of his fitness for duty. And at that stage, he was seen by the other partner in the practice. According to the complainant, this is a conflict because he was found to have suffered an injury, and then in the fitness to continue working, he was found to have no injury. So we're currently dealing with the second complaint for the partner. If the mediation is unsuccessful, then the matter is referred to a preliminary committee of inquiry, as I've mentioned before, established in terms of one of the professional boards. There, the complainant will then refer his complaint once more, and the professional will have a second bite of the cherry, as it were, to present an explanation in respect of that complaint. The matter is then considered or reviewed by the preliminary committee of inquiry, and in terms of regulation 4.9, they have the opportunity to consider the matter and assess whether it's deemed to be a serious complaint or it's deemed to be a minor complaint. If it's deemed to be a minor complaint, they have the power to impose a sanction, and the sanctions can take anything from a warning and discharge all the way to a strike or a suspension and or striking of the professional's name off the roll. In terms of fines that are imposed, currently the maximum fine that can be imposed is 70,000 rand, depending upon the nature of the offense. What is very interesting, of course, is that the 70,000 rand fine is imposed for clinical negligence. However, for incompetence, the fine is only 50,000 rand. This is a very interesting situation at the HPCSA, because in my mind, incompetence should be treated more severely than negligence. As the old adage goes, to err is human, to forgive is divine. And if you are negligent, that is a pure error of judgment. If you are incompetent, you don't even realize that you are negligent. In my view, it should be reversed. It should be the other way around. If the committee awards a fine, the professional has the opportunity to pay the fine. Because it's a minor transgression, the payment of the fine should not be recorded on any letter of good standing should the professional at a later stage wish to emigrate, and the country to which the professional is emigrating requires a letter of good standing. I know in Canada, for example, they are very strict in terms of these regulatory concerns, as well as in Australia and New Zealand. So it is one of the aspects that professionals should consider under circumstances where they have the intention. It might not be an immediate intent, but it may lie somewhere in the future where they intend to emigrate to a foreign jurisdiction where a letter of good standing would be required. If a fine is imposed by the preliminary committee, that's not the end of the matter. The professional may decide that he or she wants to have their day in court, as it were. Under those circumstances, a professional conduct inquiry will be convened, where a pro forma complainant would be appointed. That is the equivalent of a prosecutor in court. The conduct inquiry takes the nature, it's a quasi-criminal investigation, because it ends in a sanction, as opposed to an award for damages as one would find in a civil lawsuit. If the professional is then charged, the charges would invariably either be unprofessional, improper, or disgraceful conduct. Primarily, the charges are then whittled down to unprofessional conduct. However, there have been cases where a finding of not only unprofessional, but also disgraceful conduct. I think in this matter of the well-known case of the brain, where the professional had an affair with a patient who fell pregnant. He then tried to perform an unlawful abortion, abortions not being legal at the time, and that led to a significant repercussions or sequelae, which ended up in him being suspended from practice for 2 years. This was after he was struck and he appealed to the South African, the appellate division, as the Supreme Court of Appeal then was. If the professional is convicted by the Professional Conduct Committee, that is also not the end of the matter. The professional has the right to appeal, and it is important to realize that the professional must exercise all the internal remedies offered by the Health Professions Council. So the right of appeal internally is one of the procedures that must be followed. If the professional is then again on appeal convicted, the professional may then, with leave or consent of the insurer, proceed to the High Court, where the matter is taken on review. Again, if the review is not upheld, then there is a right to appeal to the South African, to the Supreme Court of Appeal. But of course, that also has to be done in conjunction with the insurer and the consent of the insurer. What would invariably happen is that the insurer would request an opinion whether there are prospects of successfully appealing the findings and the conviction. It's just something to bear in mind, because the costs are significant and the limit of indemnity provided for the nature of these complaints may be exhausted, and the professional will then be liable for the costs thereafter. Now, to come through back to what we are considering here today, the Health Professions Council during the period 2021 to 2022 received 1,503 new complaints. 893, which is almost 60%, were referred to the preliminary investigations. 528, or 35.1%, was referred to mediation, and 82, which is 5.1%, were resolved at perusal and analysis stage. Perusal and analysis stage is the following: the complaint is received, the complaint as it is received is referred to the professional for an explanation. The professional will then submit an explanation, and the committee will either accept the explanation without taking any further steps. Alternatively, the committee may then request the professional to appear at a consultation meeting. These are often held at or near the OR Tambo Airport, and the reason for that is simple. You have professionals flying in from all over the country to come and meet with them, so they hold it at a convenient location so that anybody that is from out of town can fly in, attend the meeting, and fly out again. The costs for attending those conferences are not covered by the professional indemnity insurers. However, as an observer, the professional will be entitled to have a representative present. The attorneys appointed by the professional indemnity insurers will be allowed to attend. However, they have no standing and they cannot speak. I, for one, with my charming personality, often take the opportunity to have a say. Some committees allow that, others don't. One just has to play it by ear. If one looks at the preceding years, you will see that in the period 2019 to 2020, there were 2,059 complaints, whereas in the period 2020 to 2021, there were 1,458 complaints. It's a questionable why this significant increase during that period. It is not clear what had caused it, or there was a significant spike. But what is very clear is that our population is becoming increasingly litigious. They are increasingly aware of their rights. And furthermore, there's also a move away from the personal injury attorneys litigating in road accident fund claims. The road accident fund has been under strain and pressure, and they have taken a number of steps to avoid paying claims, with all the frustration that comes with the high court procedures to litigating these claims. So attorneys have been migrating their practices. Everybody now has become a medical malpractice specialist, and you see the inexperience coming through with the large quantums that are claimed. It has become so ridiculous. I have received, for example, a 30 million rand claim in connection with a simple bowel perforation that was attended to successfully post complication, and the patient's health has been restored, albeit with a measure of scarring. The plaintiff's attorneys are still claiming 30 million. Even worse, in a matter for unlawful arrest that I'm currently dealing with, the claim amount is 70 million, with 50 million rand for general damages for a person who had not even been incarcerated in prison. So there is a spike in the quantums, there is a spike in the number of claims, and financial service providers should be aware of this so that they can advise the...
So proud of you.
They could advise the insured accordingly. Just to give you an idea of the nature of some of the complaints, I've listed all of them. I'm sure that upon request, the slideshow can be made available if iTOO can attend there too, and everybody can see. But just as I've mentioned before, I've highlighted incompetence in blue. Another aspect that has come to the fore is that there's been a lot of charges against professionals for practicing without registration. And that comes about because of a failure to pay annual fees. And that is a pure administrative issue. The professionals at times forget to pay their annual fees timelessly. They run busy professional practices and it just slips through the cracks. What then happens is that the HPCSA would suspend the practitioner, and after suspension, if you then continue practicing, then you are practicing without being registered, and that also leads to a complaint with the HPCSA, and that is then referred to a preliminary committee of one of the professional boards, and invariably you end up paying a fine, and then you also have to pay the re-registration fee. Now, the re-registration to re-register or have your name placed back on the roll is 17,000 Rand. I've always argued that that in and of itself is a penalty to call upon you to pay a re-registration fee. So to have you pay another fine is rather superfluous because there's already a fine involved. What we have seen to a large extent is a lot of medical negligence claims, misdiagnosis, refusal to treat. And the reason for these types of claims is that the personal injury lawyers who have now changed tack and decided to do medical malpractice seem to think that it's prudent to have the merits of their claims assessed at the Health Professions Council. So they lodge a complaint in the hope that the Health Professions Council's preliminary committee of inquiry confines the professional guilty of unprofessional conduct, and then they have what they deem to have is the issue of liability resolved and in the bag. They're of course wrong, because the finding at the Health Professions Council is not binding on any court of law, and you can still defend the matter in court. What is also prevalent is complaints by medical aid schemes. GEMS, Discovery have lodged a number of complaints for what they call fraud or theft or overcharging or overservicing. And the trend that we see in terms of case law, reported judgments is that these are often related to the schemes sending in undercover operatives, where the doctors are consulted with complaints or specific complaints, and at that stage, the doctor would dispense vitamins and then charge for antibiotics. They then record this and lodge the complaint, and initially it will often start off with a request for a consultation where they will say to the professional, look, we had an undercover operative, this was what you dispensed and this is what you've charged. We've gone back on our records for the last 3 years and we see that you've charged for this antibiotic on these occasions. Consequently, if you add all of the amounts up that we've paid you for the antibiotics where you possibly dispensed vitamins, then you owe us 700,000 rand. Then one ends up in a negotiation, and if you refuse, then they will invariably report you to the Board of Healthcare Funders, and they will suspend your account, etc., etc. So these are the types of things that one should be wary of, and one should be advising the insured against. It is also very prevalent in the market where you see complaints against the psychologists and psychiatrists as well as the social workers. And why is there such a large volume of complaints? Is because they often engaged in forensic practices in divorce matters, where it is an acrimonious divorce, and unfortunately the children then become pawns in this dispute. When clinical psychologists and educational psychologists are roped in to provide reports, and social workers, where the one party then wants to ensure that primary residence and guardianship is placed with him or her, and that the rights of the other spouse is then limited. These matters are very prevalent. There are also organizations, and I personally have reported an organization to the South African Social Workers Council or Social Services Council, for the simple reason that they have formed a pressure group, and the group is also making money by hosting training sessions where they train spouses. It doesn't really matter to them whether it's the husband or the wife, how to lodge complaints and how to frustrate the divorce proceedings and the children's court proceedings. And they charge a significant fee. I've seen them charging 1,500 attendance fee, and then they get 100 people to attend. You can do the math. So these are the nature of complaints. What are the trends? There's an increase. Year on year, it may fluctuate, but my prediction is that the trend with an upward swing will increase with the more and more personal injury attorneys migrating to medical malpractice, our society becoming as litigious as it is. If you take our Gini coefficient, our society, we're becoming a lot more unhappy as a people. This is partly caused by our external factors. Load shedding is an example. The reported corruption that we deal with, we see in the press. You see institutions like the post office announcing prospective retrenchments, Eskom announcing prospective retrenchment, Telkom. So the job market is becoming more and more depressed, more and more people being unemployed, and people will then endeavor to find ways to supplement their income, be it pensions, be it retrenchment packages, etc. So there will be a continued upward trend, and it is important for both underwriters and brokers to take note of this so that you can ensure that one deals with these matters as a preventative measure as opposed to trying to find a cure once the complaint is there. I've dealt with this. Another possible reason for this is simply that people also have unreasonable expectations. You know, when you take your motor vehicle to a garage for a service, the mechanic has the opportunity to switch off the engine, to disconnect the battery, to connect the computer box to a computerized system, to do an analysis. When a human being goes to hospital for an operation, there's no chance of switching off the heart and the lungs and just doing a general service. You don't have to do this whilst the engine is running, so to speak. People have unrealistic expectations that doctors are miracle workers where they can forego their own health and looking after themselves and then expect a miracle when they go into hospital with a bad state of health. I've mentioned that the RAF is not a viable source anymore. Part of our problem that we have in the country, as sad as it is the standard of education. Our standards are dropping, which means that the quality that we end up with is poorer than it used to be. In addition, hospitals are understaffed. You have nurses being poached left, right, and center by the various groups and the state. And whenever the state feels it's under pressure, it increases the salaries that it offers. So you have a migration from private hospitals to the state by nurses. And everybody is under pressure. You find yourself going into a casualty unit, even at private hospitals, where your waiting time has increased purely because of staffing issues. Now, I think important for insurers and financial service providers is to consider what you can do to improve the situation. It's important, as you all know, financial advisors and intermediaries are required in terms of their legislation to do a proper risk analysis of the insured's profile, to advise the insured properly. Thus, you need to be alive to the risks that are present and prevalent in the marketplace where your insured are practicing their professions. It is important to ensure and to re-emphasize at each renewal the importance of ethical practice. One of the difficulties that you find in professional practice is that often the administration is left to an administrative company or administrative staff, and you find a lack of attention to detail where the ICD-10 codes that are used are the incorrect codes for the specific treatment that is provided. This often results in an assessment by the medical aid schemes of your claims and the nature of your claims. Now remember, they do not have a human sitting there assessing all of this. This is all plotted into a computer program, and the computer program will then kick out abnormalities in the claims ratios. So for example, if one particular professional is charging 2-hour consultations for every single claim submitted, then that will be seen as an outlier. That will then be assessed, and that matter will then be referred to a forensic investigator who then will contact a sample of the practitioner's patients to assess how long the consultations were. Now, the difficulty with that assessment is the following. If you are phoned 8 months to a year after you've had a consultation with a professional, and you are asked, you are told, in fact, that this is a regular and a normal just assessment of whether you are satisfied with the treatment you have received from a practitioner, etc. And then during that conversation, you are asked, you attended this practice on the 10th of February 2021. You say, well, yes. Tell me, how long was this consultation? Not knowing, you'll say, well, and people have a habit of underestimating the time spent. So even if you were there an hour and you are phoned 2 years later, you'll say, oh, I was there for half an hour. And the forensic investigator then immediately has a light bulb moment where he says, oh, you see, you charged for 2 hours, consultation was only half an hour. What has my recommendation been to practitioners is the following. Develop a timesheet as part of your patient card. When the patient comes in, and then you have on your patient card, date, ICD-10 codes, nature of treatment, time in, time out, signature of patient. And what you do then on that time card, you'll complete everything, and then at the start of the consultation, you will record the time, and at the end of the consultation, you will record the time, and then ask the patient to sign next to that time card. Why is that important? When the medical aid schemes come and they ask you to prove, because that's what they do, they ask you to prove the time you spent with the patient. Invariably, there is no evidence of the actual time. So they will ask you, give us a copy of the medical records, of all the records, all the notes that you made during that consultation. This satisfied by the amount of notes that you will make, they will ask you for your diary. You can short circuit all of this by having a time card where if they ask you, prove to us how much time you spent with this patient, you send them the time card with the patient signed, proving precisely what time the consultation started and what time the consultation ended. And that should be the end of the matter. One of the other trends that we see is questions around informed consent, and that includes informed billing consent. You will see that the informed consents are often limited to treatment consents, but it doesn't deal with how much you will be charging. I say you cannot specify each and every charge that will come about, but one needs to just, as a general idea, just inform the patient that you will be charging for services in accordance with you're contracted in with the medical aid schemes, or you're contracted out, and for each nature of the service that is rendered. One should also bear in mind if additional services are required at a later stage, you must then explain the nature of that service that will be required, and again obtain informed consent, not leaving it for the first informed consent at the initial consultation. Lastly, what I would recommend is that when a complaint is received, to consult an experienced attorney to assist with the drafting of the explanation to the council. We are proud as our firm to have an 85% success rate of having claims dismissed or complaints dismissed at the initial analysis of the documentation stage. Why the 15% conviction rate percentage? It's simply, we are not miracle workers. What has gone wrong, and we can't fix that by drafting an explanation that simply doesn't take account of the true facts. So yes, there will be convictions, but often these convictions do not happen at disciplinary inquiries, but happen at the initial stage. At that stage, the professionals, we advise them that of their rights, and also that they must consider whether they want to take this matter further, because once you are then convicted by a professional conduct committee, then the nature of the conviction changes, it's no longer deemed to be minor, it's deemed to be more severe, and that will be referred or recorded on your letter of good standing. Those are my thoughts on the matter. I am not certain if there are any questions, any concerns, and I hope I haven't given you an information overload.
No, it's absolutely no information load. Rick, thank you so much. That's most informative. From my side, I'm actually going to keep you in the hot seat for a little longer because I do have a question for you. Earlier, you've been touching on the Medical Aid Schemes Act and what to do in terms of the billing sheets and the timesheets. We have come across situations where we do find that and I must choose my words correctly, that the schemes have come across quite strongly in actually requesting the clinical notes and other notes from the practitioner. Now, do they have that right to disregard the legislation which actually governs the right to confidentiality, like POPIA and any other relevant legislation?
They argue that they do have the right because they are protecting their members' interest, which is then the patient's interest. That's their argument. I've seen less frequent complaints of this nature because I believe that the POPI Act and the information regulator has dampened their spirits. But the easy answer is that you can request to be supplied with an informed consent by the patient or a consent to release the records.
Sorry,
then there is no answer. So you ask the scheme to obtain from the patient a consent to release their clinical records to the scheme. And then they just have to request their member to provide that consent, and then of course, you're entitled to release it because you've received the consent.
Okay, so that would be the most cautious approach,
Yes,
so just to make sure that the practitioner doesn't overstep his confidentiality obligation. I can see from the chat, our Lutfia Samuels has a question for you. She asked, Rick, can you touch on the importance of informed consent? We note that the HPCSA has been requesting informed consent proof when undertaking treatments.
Yes, I think, I'm not sure when that question came about, but I did in fact touch upon the informed consent, but let me just go through it again. What is required in terms of the Health Professions Act is that no patient be treated without consent. Now you have a variety of scenarios. One, where the patient is an adult person whom you consult with. There it's important to make sure that you obtain informed consent from the patient for the treatment, and as I mentioned before, as well as for the billing. You must have treatment and billing consent. Another scenario that you will confront is that you will have a patient who's an adult patient, but may not be able to provide consent. The patient's health status may be that the patient is seen when in a coma or mechanically ventilated under severe sedation. Then the patient will not be in a position to consent. Under those circumstances, it is incumbent upon the health professional to obtain consent from the family members, a guardian, a husband, even an adult child who is present and can provide the consent. Don't leave it because you can get into trouble for that. The patient who cannot provide consent also then touches upon minor patients where you need to obtain the consent of the guardians. It is often viewed by medical professionals that where the child is over a specific age, 12 years of age, and the child has the necessary cognitive abilities to understand the nature of the treatment and provide consent, then you can obtain the consent from the minor. To give you an example, the Children's Act dealing with elective abortions deals with that, where the minors can consent. But it's always important to assess the minor's ability to appreciate the nature of the treatment and the nature of the consent. Remember that the minor will not be responsible for your account. So under those circumstances, you have to consider obtaining billing consent from the guardian or the guarantor who will be responsible for the account. I trust that answers, unless there's anything specific that you need me to touch on.
No, I think you've actually answered that quite adequately. I see another interesting question that has actually come through on the chat, and that's from Deborah Lombard. Are there any implications to clients that keep claiming for irrelevant aspects and causing defamation to the practitioners?
There was a recent judgment, and please do not ask me to quote the citation. I will provide it. But there was a recent judgment where the court said that for laying false complaints with the HPCSA or vexatious complaints with the HPCSA, the practitioner can in fact sue. It would be the same as being charged criminally, where the charges are either nollied by the prosecutor, or where there was a trial and the accused was then acquitted. Under those circumstances, you can lodge a complaint, or you can start a civil claim for defamation, for laying false charges, for malicious prosecution, etc. So yes, it is possible, and yes, the members of the public should be alive to the fact that it is not a free-for-all anymore. The difficulty, of course, is one of the primary functions of regulatory bodies or the South African Police Services is to allow people to complain or to lodge complaints or criminal charges. How else would, everybody is not necessarily just a whistleblower, but some people may also be a victim of the crime or the unprofessional conduct, as it were.
Okay, thank you for that, Ric. So from our very own Marissa van der Westhuizen, the question is, we've seen a few fines imposed by the HPCSA exceeding 70,000 Rand. She asks, is she correct in saying that this would happen in the event of cumulative fines, i.e. more than one fine imposed for a specific complaint?
It may be, or my knowledge may just simply be outdated there. I still have the old regulation with the old fines, but the HPCSA may also impose cumulative fines for the different charges. So that could be the reason for the higher amounts.
Okay, thank you, Ric. And just to add to that, because when we speak of those cumulative fines, right, there has been, we do find in situations, there has been allegations that the HPCSA has leveled additional charges. What are your views on that?
Well, the difficulty that one has with a regulatory body, especially with the Health Professions Council, is that they view all complainants as lay people. So you will find that the complainant lays a complaint that the doctor impaired his or her dignity, was rude and or racist. The HPCSA would then review the records and the explanation provided by the professional, and then they may pick up that there was poor record keeping, or there was some other error in terms of the stationery, where your practice number is not recorded. They then add an additional charge in addition to the actual complaint. So you might find a situation, I've had a situation where the practitioner was acquitted of the charge relating to the complaint that was lodged, but convicted of a charge relating to poor record keeping, for example. So that does happen, that they assess the claims or the complaints and add charges simply on the basis that a layperson lodged the complaint and is not aware of all the aspects that they should look at when dealing with a professional.
Okay, but in my mind, just listening to you, where you have a situation where someone levels these additional charges, that does come across, it doesn't sit well, because it does seem like it's quite unfair, because you're considering one complaint, but then something else is toppled on, and the practitioner is not given a fair opportunity to be heard. And I just want to wrap up with my last question to you. The last question that I have is, do you feel that the HPCSA is an effective body? And in terms of their turnaround times, does this frustrate our practitioners and stress them out to no end?
Let me start off with the tail end of your question. Yes, practitioners are frustrated. They're not only frustrated, depending upon the nature of the complaint, they can actually be hamstrung. For the longest time, we've always lived or labored under the impression that doctors, especially surgeons, have a God complex. But it's important that they must have the God complex because they make life-changing decisions. You don't want to lay on the theater table with a practitioner who's filled with self-doubt and is hamstrung to the point that he can't make a decision. That's the last thing you want. And that is precisely what happens when many doctors receive these complaints. It also happens when they receive summonses where they are accused of negligence. They then find themselves in a situation where they don't want to be in theater anymore. You do, of course, get the health practitioners on the other end of the spectrum. Thank goodness they are few and far between, who simply carry on as if nothing's happened, irrespective of the number of patients that have died under the scalpel. I always say, when I deal with these types of cases, both from a regulatory framework or from civil litigation and or criminal prosecution, I say to the professional, remember, you've done nothing wrong. What has happened is that somebody feels that the services rendered by you is below the standard that they expected. These could be unreasonable expectations, or they may simply be that in terms of a school of thought, a medical school of thought, you were under the impression that what you were doing was correct. Now, if you do that, and that is not an unreasonable act, you're not liable or you're not guilty of unprofessional conduct. It is simply that you made an error of judgment that is not necessarily negligent. The next thing that I say to them is that I get paid the not so big bucks to worry for you. So you stop worrying. I will do all the worrying about this case. You worry about the next case that you're dealing with. You worry about the next patient that you're operating on. We will do all the worrying. And fortunately, the way we work, I never work as an individual. I always work as a team. The very experienced claims advisors and litigation officials at iTOO form part of that team. But there's a very important cog in that wheel, and that is the practitioner who sits down with us and explains to us precisely what happened. And thereafter, we would appoint experts in the same field who will also act as advisors. And so you don't have to worry. With the Health Professions Council, the first question that I always get asked is, are they going to revoke my license? It's always the first question. And I say, no, to revoke your license, you have to do something very, very serious. You actually have to get very close to killing your patient, or with some of the boards having relationships with your patients. The psychiatric and psychology board is very serious about that. It's also very serious about supersession, where you take over another professional's patient without informing the professional. And they're also very serious about having multiple relationships. Multiple relationships being, you are appointed to provide a clinical treatment, and then the patient's attorney ropes you in to provide a forensic report. And this often happens in divorce matters, where it starts off with being referred for an evaluation, and then they ask you for a report, and now suddenly you've written a forensic report that is shared with the court. That's a multiple relationship that should be avoided. You're either providing clinical treatment or you're appointed to do a forensic evaluation. You cannot do both.
Thank you for that, Rick. Thank you. And I just like to touch on what you've just said now about we all work as a team. And that is why we always love to say, you know, if ever a client or a practitioner does have an issue with the HPCSA, sorry, is knocking on their door, we're just a phone call away. Please do not hesitate to notify us of any complaints or any approaches from the HPCSA, because at the end of the day, we want to see how we can help and support our insureds to actually reach the best possible outcome for our clients. Thank you to everyone on the call, and a big thank you to you, Ric Martin. Thank you for taking the time from your day to join us. It has been such a great session, and to everybody on the call, it's great having you with us. And if you do have any other questions, please feel free to mail us or give us a shout. Thank you so much.
Thank you, everybody.
Thank you, Nadia. Thank you,
Thanks,
Rick.
Nadia. Thanks,
Okay.
Rick.
Bye, everyone.
Cheerio. Bye-bye.
Thank you.